distinguished guest. I'm very pleased as well to lecture today in this very important event. My name is Dangerousness. I'm an advocate working in the legal aid in the Ministry of Justice. And I'm the National Supervisor for Mental Health Involuntary Commitment. We are speaking about civil commitments, not about criminal one. And the civil commitments in Israel represent more or less 75% of the patients that are hospitalized in Israel, whether 25% are by court order in criminal proceedings. Okay, so I will first speak about the first 2 minutes about the legal aid in the Ministry of Justice. The legal aid is actually representing people that are disadvantaged in legal proceedings in all kinds of proceedings, whether we are speaking about minors. Of course, there are the public defense attorneys, prisoners and detainees, disabled people, mentally and physically limited people, which we are dealing with, minority groups. We are dealing also with residents in Israel that sometimes are in Israel. We are speaking about family proceedings, labor proceedings, housing proceedings, and in every aspect proceedings that we are dealing. We are dealing also about victims of crime that have to be presented in court. And of course, we are speaking about various legal fields that we are dealing. We are speaking about 80,000 cases each year. The last year was 80,000. And we continue. If we are speaking about mental health civil cases, we are speaking about right now 5,300 cases that are dealing with civil commitments every year, which represent 8%, more or less 7% of our total cases dealing with legal cases, which means that it's actually a very big proportion of cases. We are working in 15 hospitals in Israel, or hospital or mental health department in general hospital. And we are dealing not only, of course, with the right of freedom of the patient regard his right to be free from compulsory treatment, but also about the treatment that he receives, whether we are speaking about physical restraint, like Dr. Tal Bergman-Levy previously mentioned about a life change before Noah and after Noah. Well, I can tell you as well that my life changed as well before Noah and after Noah, Advocate Primor and myself represented Noah in the civil proceeding in court and made this dramatic change actually in the legal discussion about physical restraint. I will deal with that a little bit later, but obviously Advocate Primor is also here and she will speak by herself about that. Okay. Now I would like to speak a little bit about the legal representation of mental health patients prior to the Mental Health Act that was actually amended in 2004. The amendment itself, of course, the definition of civil commitment, the process in somebody is actually committed to an hospital, more legal issues as far as time will allow us, and a very short summary. Legal representation of mental health patients prior to the amendment of the Mental Health Act. Actually, before the amendment, there was no free legal representation given prior to 2002. We didn't have any free legal advocacy in Israel regarding people that are mentally hospitalized in civil commitments. The law actually did allow somebody to have a lawyer, a private lawyer. But obviously, there are two problems with that. One of them is nobody actually told him. And that's a problem in itself. Somebody is committed to an hospital. Nobody is telling him you have the right to even appoint a private lawyer from your own money. Nobody told him. Even that. And the second issue, of course, why he has to have a private lawyer. Why cannot he have a free legal advocacy? And this issue actually, prior to 2002, and I'm stressing, in Israel, it was in 2002, whether in major European countries, this issue was not even a problem. In major European countries, actually, and in the US as well, there was free legal advocacy. But in Israel, it was not the case. And I will say what the change actually said. But of course, a person we wish to make an appeal against his commitment could not do so. And that's why the jurisprudence about this issue prior to 2002 was very, very limited. In very small cases, that was actually on voluntary NGO basis of the association of the civil rights that made here and there some appeals. But that's all. And no knowledge of its right to appoint private lawyer, and of course the legal right that he had to make an appeal to the Israeli district court on the second instance. Well, it began to change, first of all, because of the court jurisprudence. In the very small, limited cases that went to actually the majority of them in the Tel Aviv district court, and in Israel the district court is the second instance, which means it's actually a very high instance in Israel. We had jurisprudence that says, well, it's not normal that somebody could not have even a lawyer to represent himself, and the state should do so. Then there was a petition made by the Civil Rights Association, it's not a movement, against the Israeli Ministry of Health and the Israeli Ministry of Justice to the Supreme Court. In 2002, there was an interim model made in Jerusalem. I was actually personally one of the 3 lawyers in Israel that were in this model made by the Ministry of Justice. And after 1 year, we made our recommendation to the Supreme Court about the necessity of legal aid on this issue, and that made a lot of changes, of course. And then the court decided, after the Ministry of Health and Justice accepted, and there was the amendments of the Mental Health Act made in 2004, to make a gradual implementation of the legal representation in Israel. In 2007, all of the 15, March 2007, all of the 15 hospitals actually had legal representation. Right now, we are speaking about 44 lawyers, external lawyers, and 6 inside lawyers from the Ministry of Justice. If we are speaking in 2002, as I remember myself, we had only 2 lawyers dealing with this issue, which is a significant change, and still it's not enough if we are speaking about the numbers of people that actually needs representation. When we're speaking about the mental health, I already told that there was the civil involuntary commitments made by the district psychiatrist. It is important to notice that the district psychiatric in Israel can make an order to civil committed someone, but it does not actually medically check the person by himself. He's relying on evidence made by another psychiatric, which himself does not know the factual based on the dangerousness, which we'll be speaking later on. And of course, he has the right to be represented by civil legal aid, and there's the criminal proceeding on the 25% of cases, decision made by the court. Of course, what is very important in Israel, well, in the last year maybe less, but still it is an issue that if somebody is civilly committed, it is very important, it has to be on a due process based. There is actually a jurisprudence, conflicting jurisprudence on this issue, but the Supreme Court already made his final decision that it is not the due process that by itself is enough, but still one has to be actually check if every specifically process has been made. Somebody has actually to be invited to be medically examined if there is evidence that is dangerous to himself or others. He has to refuse, and only if he's refusing, after explaining what's the meaning of the refusing, one can actually make an involuntary order or civil commitments. The main requirements for civil commitment in Israel, of course, is a mental health disease. Mental health disease is a legal criteria, and I think that before when you mentioned that is still a legal criteria, not a medical one, which of course might arise issue regarding, for example, eating disorders or any other disorder that cannot be actually specifically mentioned as a mental health disease. Present danger to himself or other by facts, which means we have to present facts to the civil committee, psychiatric committee, and a legal causation between the danger and the mental health disease. This also is a very important issue. I can tell that the last year I have dealt a lot of cases regarding the third criteria more than any other year before. But still, the majority of cases that actually we present and we can make argument is about the factual danger to himself or other people. Now, you have to understand when we are presented so many people that we have all the time ethical dilemmas between the patient's will, how the psychiatrist can see them, and the patient well-being, or the patient can see a doctor. Well, that's more or less to show you where we are inside. In this sphere, we are dealing with all the time. Now, of course, the right to be medically treated and protection of society is a very important things to do. But, of course, when we actually deprive somebody of his liberty, we have to do it with minimal harm, and, of course, to make any alternative, maybe, options other than actually make in the closed environment. Now, what is the process? The process is, of course, danger to himself and a mental disease. There has to be a causation. Then he has to be refused to be examined and invited. When he is actually invited to be examined by the district psychiatrist and refused, there is an order that he has to be civilly committed, which is valid for 7 days, and then we can extend it to another 7 days, up to 14 days. He can make an appeal against this order. I still remind ourselves that the district psychiatrist actually did not medically check the patient. He's relying on another medical advisory, psychiatric. Now, the process, of course, is after the 14 days, or if there is an appeal against that, there is a psychiatric committee that actually can extend the hospitalization, and of course he has the right to make an appeal to the district court in Israel. Now, what's actually dangerousness? That is an issue which is all the time in discussion between the legal sphere and the medical one. Well, I can always argue that threats of self-inflicted harm are not always sufficient. If by themselves there is nothing more, maybe that's not enough. But the issue of the gap between the hospitalization and the events, if somebody is speaking about something that happened 1 month ago and then now he's hospitalized, obviously the gap between them actually can present a factor why he should not be hospitalized. Requirements of evidence, we are not speaking about Israeli law of evidence, but still we are speaking about an evidence-based issue which is defined by the law, and events that occur actually during hospitalization can be considered as justified if the initial civil commitment was not justified, which means if I actually took someone and put him in an hospital and it was not justified, and then he actually reacted and he made a sort of a question, what we can suggest, that in itself is not a justification for his hospitalization, because actually it was not justified in the first place, and it can be considered as actually is resisting an unlawful act. That's not, of course, me saying that, but the district court in Tel Aviv. Now, I just want to mention that this issue is less occurred in the last years, but still in the first year that we presented, we had a lot of cases regarding that. Now, what's up? Down, sorry. Okay, and of course, the legal criteria is not a medical one. Threats of, say, requirement of evidence, and of course, the need to verify alternative and less restrictive measures. Now, there is, of course, further legal issues which we are dealing with. One of them, of course, and I think that I told you about Noah case, it changed my life. Well, it definitely changed my life, because after 2006, we were dealing more and more about not only the right of person to be free from his hospitalization, but also the conditions that he was inside. Well, I saw Dr. Tal Bergman-Levy, and she showed us a very improvements in state of the mental health hospital in Israel, but still, there are a lot of hospitals that are, their condition, the physical condition, are very, very bad. Even the appointed judge supervisor in Israel, I'm sorry about my English, I'm dealing actually to speak in French much fluently than English, but I will try. He made remarks about the physical condition in the hospital, which are very poor, and especially in the sole confinement person that actually is solely confined to hospitals in Israel, which means that there is a lot of work to be done, and of course about the physical restraint. In our case, this girl, this woman, that actually was 24 days in the hospital, there was no justification whatsoever. And I argue here that sometimes people that are in that situation can be actually violent after that. That can cause violence and not the other side. 5 minutes? Okay. Okay. So I will terminate and say that the issue that we are dealing now is mental disease, whether autism and anorexia, we have no, actually the situation in that respect is not satisfactory, and some of them are actually hospitalized in mental health hospital, which they should not be so. The issues of consent, what is consent to be hospitalized, is an issue that we are dealing that constantly. And to finish and to terminate, I will say that this year I can say with certainty there is a better dialogue between the medical and the legal profession, but still there is a lot of work to be done between the professions and of course the Ministry of Health. Ongoing new dilemmas every year, every day I have a new dilemmas that I have to deal with my lawyers and with patients. And of course, we can only assume that we can improve that and much more than before. Thank you very much.